Good evening. Welcome to the December 19th meeting of the Town of Gorham Board of Appeals. The meeting will come to order. This is a public proceeding, and unless the board specifically votes to go into executive session and asks everyone to leave the room, you have the right to hear everything that is being said and to look at all exhibits that are offered. Please notify the chairman if you are unable to hear or see. The board works from a prepared agenda, and we will be considering tonight's items in the following order. There's an agenda printed, but there'll be some administrative stuff at the beginning of the meeting, and then Agenda 2403, which is the appeal of Christina Mitchell, and then Appeal 2404, which is the appeal of Carol Molker? Hopefully I didn't get that name too bad. Molker. Thank you, Carol. For each case, the proponents will be asked to proceed first and then be available to answer questions from the board. After all proponents have spoken, the opponents may make their presentations and then be questioned by the board. After all opponents have spoken, each side will be given an opportunity for a brief rebuttal. The meeting is being tape recorded, and it is very difficult to hear what is being said when multiple people speak at the same time. Please refrain from interrupting others as they speak. Questions should be addressed through the chair. We ask that each person offering testimony come forward to the microphone and begin by giving his or her name and address. In each instance, the burden is upon the applicant to demonstrate compliance with provisions of the applicable ordinance or ordinances. Applicants for variances must specifically address and prove compliance with each of the four undue hardship criteria. Following a decision on an application or appeal, toward the end of the meeting, the board will prepare a written decision indicating its findings of fact and conclusions of law that will be mailed to the applicant within 7 days of the board's vote. The applicant is free to stay during the written decision process, but is not required to. If your appeal is granted, you must obtain or file the appropriate paperwork prior to commencing any action. If anyone wishes to appeal the board's decision, you must do so to Superior Court within 45 days. Are there any questions about what I've just read? Seeing none, we will step right in. The first thing we'll do is a roll call. And I guess we'll go down the list. Michael?
Here.
Gary is not with us. Court's here.
Here.
Mr. Sterling?
Present.
And I'm going to make you say your name again.
Oh, good.
Yeah.
Pavel Binchak.
Pavel, and then Mark Curtis on the chair. So there's a roll call. And also with us this evening is Scott Dvorak, the Code Enforcement Officer. Mark Bowers.
Mark Bauer, I'm representing Scott tonight.
All right, good. And then?
I'm Brandon Mason with Perkins Thompson, representing the Board of Appeals.
Yep, thank you. So the first item on the agenda is just a little bit of housekeeping here. At the previous Board of Appeals meeting, it was discussed that whether or not we should be performing the Pledge of Allegiance like other town boards do. Since we had a limited number of attendees that evening, we tabled it and then brought it forward for this evening. So there was a proposal to stand for the Pledge of Allegiance before each of our meetings. Does anybody have a discussion on that particular item?
Yep.
Okay, all right.
As I said last time, I am opposed to it. I don't see as it has any relevance to what we're doing. I'm certainly willing to pledge to all the citizens of Gorham to listen carefully, to look at all the evidence, and to deliberate honestly and fairly, but I don't see any need to pledge allegiance to the flag.
Thank you.
Done it for thousands of times.
Sure. As have I. Other comments or discussion? I believe for the reason it was brought up is because other town boards, it's just been a standard operating procedure to begin each meeting with that. So I'm for it because it doesn't, I mean, the particular pledge doesn't, I actually appreciate what this country's done, and I'm not saying that you don't by any means. I just, and I understand where you're coming from, so I'd be happy to do it. Any other discussion? We have a motion to add it, or no motion, or?
I'll make a motion to add it.
Okay, we have a motion. Do we have a second? I'll second it. Any discussion before we vote? All those in favor? 1, 2, 3. All those opposed? 1?
I'll abstain.
Abstain. All right, so it sounds like we're going to add it. So at this point, I say we stand for the Pledge of Allegiance. Or those that would like to, please. How's that? It's not a requirement. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Check that item off the list. Thank you for those that joined in. So we also had a decision document procedure discussion as well. And I believe that what that was wholly related to was once we've created a decision document, I think we wanted clarification for whether we voted as a board to generally allow the chair to sign for the board, or if we wanted individual signatures. And if we're going to allow the chair to sign for the board for the decision document, what is the procedure? Do we, and I think what is appropriate, hey Dan, in my opinion would be that each board member gets a chance to weigh in on the draft, either by email or stopping by the office to see it, however you want to do it, and then kind of speak now or forever hold your peace kind of thing. And then once it's reached its final draft, allowing one person to sign rather than forcing all of us to stop by the office and give a physical signature. So that's kind of the discussion that we had. And does anybody else want to bring that forward, or a concern or a procedure that we could change to make it easier or better? While you're contemplating that, let the record show that Dan Nichols has arrived. So he missed the roll call, but he's here for the rest of it.
Thank you, Mr. Chairman. I don't have any objection to it. I think it makes sense to streamline the process as much as we can. And, you know, we all, in open proceeding, vote and have a chance to review the document, so I've got no concern with the board president signing on behalf of everyone else.
Others? I think it makes it convenient. That way we're not making the applicant wait. But I do think it's very important that each of you, when that email version comes out, take the time to review it and respond to that email. Again, there should be no discussion in that email about the case itself or the appeal. Just simply, yes, we agree that that's what we voted for, or no, there's a typo or something's wrong and we need to fix that kind of thing. And then once we get to that point, I think we're in good shape, and I'm happy to sign. Do we want to make the motion? Do we want to make it so that we vote each time to do that, or do we want to make a motion that for this iteration of the board, that's kind of a standing rule until we change chair?
The latter.
Okay. Any other discussion?
You gonna put a time element on this?
Yeah, till the board changes. I think that would be the thing, till either one member of the board changes or we change chair. Does that make sense to everybody?
Yeah, the only issue there is, I guess the motion would have to state that, because otherwise, if it's going to be adopted as a procedure, I think it's just going to carry
Yeah.
forward regardless of who's here.
Right. And
I don't know if we want that.
I would personally rather just have each board, the way our bylaws are written, we're supposed to meet at the beginning of each year
Right.
and vote for a chair. And to me, at that same meeting, we should vote for the chair and then either vote to extend that rule or pull that rule back. I agree with you 100%.
Okay.
That makes sense.
I would entertain a motion to kind of restate that so it's very clear. Does anybody want to take a swing at it?
I'll take a pass. I'll move to enact a procedural rule that permits the board chair to sign the final decision document on behalf of the entire board, after giving each board member an opportunity to review that document. That rule should remain in effect until the board composition changes or the board president changes, at which time the board would vote whether or not to renew it.
Gold sticker on that one.
All right.
I like that.
Second.
We have a second. Any discussion? or
Yeah, so
addition?
maybe, do you want to just say annually?
Yep, sure.
Takes care of
That works for me.
the other language.
Second, agree to the annual?
Second.
Okay, there we go. Perfect. Any discussion on that? I think it's clear. All in favor? That looks unanimous to me. Thank you. Now, moving on to the actual applications that we have in front of us. First application, well, actually, I should just touch base. Everybody received the 2025 meeting schedule via email. Do me a favor, plug those meeting dates into your calendar, and that doesn't mean we meet every single one of those, but please kind of block those out for availability if we can. Any discussion on any of the dates?
Did we approve minutes?
Did I skip that? We have minutes. Oh, yeah, I did skip that. Look at me go. Thank you. So we have the approval of the October 17th, 2024 Board of Appeal minutes. Everybody received a copy? Discussion? Motion?
Make a motion that the minutes of the October 17th, 2024 meeting be approved as presented.
Excellent. Second? Yep, second for Michael. Further discussion? All in favor? Oh, all opposed? All right, so,
Also abstain.
okay, so we have Mr. Sterling, Mr. Nichols, Mr. Wiseman, and Mr. Curtis who voted for it, and then 2 abstentions. Thank you. All right, so now we are on to an appeal. We have, first appeal tonight would be the Appeal 2403, Administrative Appeal from Christina Mitchell, property owner and petitioner, is seeking an administrative appeal for map 6, lot 14, zoned South Corner Commercial Corridor, 34 County Road, contract zone. At this time, I'd like to ask the applicant or the applicant's representative to step to the podium and introduce themselves.
Good evening. My name's Susan Duchesne. Can you hear me okay? Okay. I am here with
Mr.
Chrissy.
Shane, could I stop you for just 1 second? I'm realizing that I should, my fault. Just for the board's understanding, Mr. Dvorak, a couple things. When they were making this application, Mr. Shane knows that I'm the Appeals Board chairperson. She was trying to get an application in. She called me as they were putting the application in. I just want to make sure everybody's aware that I received a phone call. Mr. Dvorak, I think, was witness to the phone call. And so I just want to make sure that the board is aware. It's not going to affect anything that I do tonight. Also, and I believe the applicant, after the application was put in, the applicant called my cell phone, left me a message. I forwarded that to Mr. Dvorak, who then notified the applicant that because the application had been set, that it wasn't appropriate, unfortunately, to contact me. But I just wanted to make the board aware that there was some contact, and happy to give any more detail if anybody has a question on that before we move forward. Seeing none, thank you. Just wanted to make everybody aware.
Yep, thank you. Christina Mitchell is with me tonight. I actually have been helping her with developing her property at 34 County Road. When this all started, this actually goes back to July. I've known Chrissy's family pretty much since they moved here, but they've been here for 44 years, ran their business from this location, have lived at this location that entire 44 years. I think Chrissy left and got married and her parents passed away and she came back there. Anyway, back in July, Chrissy had called me to ask for my help with her developing the property. I went out, I looked at the apartment in the basement that she had, told her that it didn't conform. I mean, it didn't have any egress. She told me that Freeman Abbott had been out there, that he told her it was fine. Anyway, I asked her to reach out to Scott, which she did. Scott helped her through the process to bring that up to code, which she did, and put the property on the market. At the time, she was going to develop the rear of the property, and still is going to develop the rear of the property. And she asked Scott to be able to build a house for herself, her husband, her handicapped sister, on one of the lots in the back that didn't require subdivision approval. Scott advised her that she owned a garage that would have to be torn down, which she did, tore down. She needed to engage a surveyor, which she hired BH2M, to survey the properties and provide him with a copy of the surveys and the deeds so that she could move forward, which she did. Then she submitted the building permit along with a building plan, yada, yada, like any other building permit. She asked Scott if, after going through the contract zone, if there was a way to, there's no ADA requirements in Gorham. So Gorham does not, even though we have 3 town planners, we have nothing that addresses ADA. So the state, if any of you have seen, is suing several towns right now for not having ADA compliant in their ordinance, but Gorham is one of them. They're not being sued yet, but I'm sure they will be if they don't do something about it. So one of the requirements under the contract zone, and there were 2 ways to look at the residential piece, but one of them said the residents had to be on the 2nd floor of the business. So one garage she was keeping on this back lot to continue her business, but asked, because her sister's handicapped and has been for 60 years, that could be built on the ground floor. Scott reached out in his defense to the town's attorney. We got a answer back saying, yes, that could be done. She could build a residence on the 1st floor. We proceeded. Let's see. Scott did ask for a final cost on the project, the house project, and she'd already given him the copy of the deeds, and he asked for an updated plot plan, which she had shown the garage that was existing, but anyway, that was done, submitted to Scott. He said the permit would be ready after that. Then she was contacted by Scott saying that Tom Poria did not agree and was not going to issue a permit. Chrissy's attorney contacted the town manager, asked for a meeting, which seemed to be appropriate. Town manager responded was, you can call Tom Poria. So attorney went back to Ephraim and said, we don't want to talk to Tom Poria because that's where our problem is. We want to talk with you and Scott and Tom Poria if he wants to be there. Finally, the town manager did agree to be at the meeting. We went to the meeting with the appeals application in hand. The town manager did come. He didn't engage. He didn't introduce himself to anyone in the room. He didn't speak to anybody, but he did sit there. I guess he did sit there. Tom proceeded to say, well, he didn't know on the ADA. He thought it was the builder problem, yada, yada. But then, anyway, long story short, he agreed that he needed to look into that and he would get back to us, within a couple of days. So we held the appeal until he did that. Then Chrissy received a letter from Tom Poria, not Scott, telling him, and you have a copy of that letter, that, I don't know what he really said. I guess he said that they didn't realize it was a contract zone, which they certainly did, because Scott was privy to it all along. The town attorney in one of her emails actually asked somebody to share the contract zone with me, so I know what I'm looking at. So, I mean, everybody knew. Everything was on the table. It was very transparent. Anyway, after that meeting, that letter came from, and so we went ahead and filed the appeal. I think that meeting, okay, so the letter came back to us on October 31st, 4:37 in the afternoon. I point that out because that's a Thursday and Gorham doesn't work on Fridays. So yet another week goes by. Now we're We've gone from July into the end of October. This is someone that's paid taxes in Gorham for 44 years and done business here. Anyway, long story short, Monday morning, they get their appeal. We asked Scott if it can be put on the November meeting, because obviously we were ready to submit it a week and a half earlier. I think Scott was going to look into that, if I remember correctly. Tom came back and said, no, you have to follow a certain schedule, whatever. Now you got to wait till the end of December. Okay, now we're July to December, and here we are tonight. Let's see. So anyway, this is basically a 4-part appeal, and I'm sorry to make it, I tried to make it less confusing, not more confusing, and maybe I made it more confusing, I don't know. I think one of the biggest issues here, and I don't know how we're going to hold on to a good CEO in Gorham if he can't make a decision that doesn't get overrode by somebody. The ordinance is crystal clear. CEO has the final say, not Tom Poria, not anybody else, not the town manager for that matter. It's the code enforcement officer. So I would just really like this board to clear that up, because I think it would solve a lot of problems in Gorham, not just ours, but a lot of other people's. The next piece is, the building permit was ready to issue. I think it's still sitting down there all written up. She spent money on tearing down a garage, hiring engineers, hiring lawyers to draw up deeds, jumped through every single hoop that she was asked to do, which they were legitimate hoops that needed to be done to get where she needed to be, but then she never got where she needed to be. So I think that's kind of a 2 and 3 combination with the whole second floor. I mean, we have 3 town planners in Gorham, and we need a town lawyer to tell us how to read our ordinance? I mean, it just doesn't make any sense. And then when the lawyer does rule and makes an opinion they don't like, oh, yeah, we don't need the lawyer anymore. So we're going to go back to this one and go with his opinion and forget Scott, because he doesn't mean anything. So it's just so many cooks in the kitchen. I don't know. So anyway, that's kind of a 2 and 3 part thing, I guess. And then the 4th item, this same project was brought to the council to do an amendment to the contract zone. The contract zone, again, crystal clear. The council reserves the right to make amendments as they see fit, whatever. We went to the council meeting, and right before the council meeting, the council was advised that they couldn't amend a contract zone, which again, I guess the council should have probably looked into that a little deeper to see if they were being given good advice, because they really weren't. And that the comprehensive plan, that the amendment didn't meet the comprehensive plan, even though the amendment is almost identical to what Hans Hansen did 2 years earlier, right up the road in the same zone. And what the comprehensive plan says is that you can make any changes you want. I mean, anything can be challenged, let's face it. Anybody can sue anybody, anybody can challenge something. The worst thing that happens is I guess if this ever got challenged, is you lose your approvals, which I really don't think was a big fear. I don't know, I guess I don't even know why the town planner is advising the council and not the town manager. But that, again, that's not my position to decide. So anyway, I think the comprehensive plan was very clear. It says, provided you're within harmony of what's around you. Residential houses is what's in the area, not people that sell tires out in the field, or out behind a bunch of houses, you're going to put a restaurant. I mean, it's just crazy. But anyway, I didn't write the ordinance. So I think that's another issue, too, that the council can certainly consider anything that's on the table, with or without a town engineer, with or without a planner telling them what to do. That's for them to consider. And the contract zone allows it, and the ordinance allows it. So we're both here. If you have questions, we're happy to answer them. And I appreciate your time. And like I said, I didn't try to make this more complicated. I really didn't. So hopefully it's understandable.
All right. So I have a couple questions to kind of start. We are definitely going to give some opportunity to anybody who has an opposition to this to speak. But I just want to be clear on and try to help the board, because I know I'm not clear quite yet as to what your appeals are really for. The first appeal that I heard was basically you're appealing the idea that the ordinance says that the code enforcement officer has a certain amount of authority and can make certain decisions.
Correct.
And what you feel happened, and we'll get more information on this, is that the code enforcement officer did make a decision, and that outside of that decision, somebody else in this town office changed that decision.
Correct.
Okay.
After thousands of dollars were spent.
Right. So the first thing you're asking us to look into and possibly rule on is whether or not, once the code officer makes a decision, can anybody else change that decision without the appeal process?
Correct.
So that's the first thing. The second thing, you started to talk about the building permit that was essentially ready to be issued, and the applicant had spent some time and money on that, but the actual building permit was not issued or was issued?
No, we have an email saying you can pick it up once you show us the cost of, the house being built and update the plot plan. So we did both of those things.
So you met the conditions that were given to you?
Correct. And then we were told, Tom said you can't have it.
Okay, so the first thing is whether or not somebody can change that decision, and number two, since you had received a decision and met the criteria, you're essentially asking us to tell the town to give you the permit.
Correct. And part two of that is that the town attorney did in fact give Scott, to Scott's credit,
Yeah.
he wasn't certain on could he allow this to be built on the main floor when there's one spot in there that says it needs to be on the second floor. So he reaches out to get an opinion on that. The opinion comes to us that says, yes, he can in fact build it on the first floor. I don't know if that was because of ADA or if there was another place in the ordinance that allowed it. I don't really care. The bottom line is that she ruled that way. And that was revoked by Tom Poria.
All right, so does the building permit that you applied for include the dwelling unit on the ground floor?
Yes.
Okay, so realistically, those two are kind of tied together, as you said.
Yes.
And then the fourth part of the appeal is essentially the question as to whether or not the town council can change a contract zone or not.
That's basically it, yes.
Okay.
Like I said, this same piece of property goes in front of the council.
Yep.
And the council is being told that,
Told by who?
by Tom Poria.
Okay.
That the town attorney advised them that they could not vote on something, they could not vote to amend this because it didn't meet the comprehensive plan. Well, that's up to them to decide
Okay,
if it meets the
understand.
comprehensive plan.
So, and we're fortunate, we have two attorneys here tonight to help us through this. The town attorney opinion that you're speaking of, from what you've read, was it either of the two attorneys that are here? Mr.
Yep,
Bauer?
Mark
Okay, so
Bauer.
that's great, we're going to get some firsthand
The
knowledge on that.
first, although not on the second floor issue, that was Natalie Burns.
Okay. All right. Does anybody else on the board have a question for the applicant at this time? We're going to get plenty of opportunity, so, okay. I was just trying to get a lay of the land here. At this time, I would ask if there's anybody from the public or an abutter or anybody who wants to, kind of give a different opinion. It doesn't necessarily have to be opposition. If anybody else would like to speak on this particular item. Oh, please step to the podium.
Hello there. My name is Madison Carey. I am not quite sure of all the legal processes involved here, but I'm here as a mom, and I am a current renter at 26 County Road, where I live with my husband and 2 children. This is also the residence where Ms. Mitchell claims ownership to a right-of-way that is through our driveway and part of our backyard. This particular portion of property has posed a problem to my family, as well as my in-laws who live next door and also share the right-of-way. Our family has 6 young children under the age of 6 living on the 2 properties combined. One particular day, my family and I were leaving our pool, and we let our 3-year-old nephew run on ahead to play on the playground in our back field, a place where he should be perfectly free to explore in safety. As we were all walking a little behind him, we saw a vehicle zoom way too fast across our property. It turns out this was Chris's husband and another passenger. We all screamed in fear for Kaya's life, and we were relieved to know that he had not yet exited the pool fence because he had stopped to pick up some sticks. We can't imagine what would have happened if he had in fact run ahead of us. We had a discussion with Chris at that time about the incident and had asked her to please watch her speed when driving on our property. This is where the conversation of the subdivision intercedes with our problem with the right-of-way. At that time, we learned of her plans to run construction trucks across our driveway and our property to build the subdivision. We have spoken with an attorney about this particular right-of-way. Their opinion is that the original intention of the right-of-way did not include construction trucks for a subdivision, so this would create an instance of overburdening the right-of-way. We also never dreamed that we would have neighbors who had so little regard for the 6 young children who live on the 2 properties where the right-of-way crosses, which has been expressed in numerous ways. Since the altercation with the 3-year-old and the fast-moving vehicle, Chris has driven across our property an increasing number of times, sometimes multiple times per day. When she does this, sometimes she has her camera out, filming our home and our family, and has lost control of her emotions in front of my children a number of times, raising her voice at us or our next-door neighbors. Because of this, our 6-year-old children have very limited boundaries in our driveway and back property for where they can play and ride their bikes. Not only that, but she has also exited her vehicle on our property and screamed obscenities at us in front of our children, calling us, and I quote, effing drug addicts, while accelerating at a dangerous speed. I have video evidence to prove this.
I'm going to stop you just for a second.
Yeah.
And I can appreciate all of what you're doing. This board has a limited scope of what we're going to review tonight.
Completely understand.
A lot of those neighbor dispute comments, they're not going to be helpful to what we do. There's probably a place for those, and I'm not trying to stop you from giving your opinion on this stuff, but recognize we're looking at the 4 items that have been expressed in front of us. And I don't want to stop you, but is there something in your comments that's going to get to whether or not those are something that we should or shouldn't be considering, or how will they, if we grant or don't grant this, how will it directly affect you? Because I would encourage you, I mean, if you've got a complaint against your neighbor, you should definitely call an authority, and you said you've already talked to an attorney.
Yes.
I mean, so again, I'm not trying to stop you, but I'm just trying to narrow the focus. We've got to pull this whole thing together at some point.
Absolutely. Thank you so much, Mr. Curtis, for expressing that.
Yep.
I will get to my point more quickly then. I would like to make mention that County Road could be significantly overburdened by the additional traffic of an added subdivision near our home. One week in particular, I recall 3 car accidents right in front of my house and 2 within 24 hours. These involved cars that wrecked into a ditch because of the amount of cars already traveling on the 2 tiny lanes on county roads. Instances of cars crashing into the ditch right next to my house many times, I fear, would only increase with the addition of a subdivision. Not to mention the traffic between 3 to 5 p.m., unheard of in our great state of Maine, is already nearly unbearable. Again, I'm a mom with 6-year-olds in the car. I hope I've clearly stated not only my concern for my children's safety, again, with construction trucks that she has blatantly expressed she doesn't have much concern about the safety of my children. So if there's construction trucks that are driving through our property, I fear they would also share that not being burdened by the safety of my children, but also that the fear of overwhelming our already very busy road. So I'd also like to end with a message from the owners of our property. They have agreed to withdraw concerns about the right-of-way access and conflict if Chris Mitchell will sign the right-of-way over to the owners and agree to stay off our property completely. I appeal to you again that our gravest concern is not only overburdening the road that we live on, which is already very busy with just 2 lanes, but also the safety of my children. So thank you so much for allowing me to share.
I just have one question, because it seems like you know a lot more about what's maybe proposed, but the current iteration of what we're talking about this evening, my understanding after reading through this paperwork, is essentially a conversion of an existing building and the addition of a new building, a single unit added. Are you under the impression there's more plans to develop something bigger in the future?
From my understanding, that there's a proposed plan to make a subdivision on this particular space and use this right-of-way, which is why I'm here. I wouldn't be here otherwise.
No.
Again, a busy road, I don't want it being more busy, but particularly that our property would be used to have these construction trucks go in and out freely.
And I would encourage you, if they do bring that plan forward, the planning board would be a great place to address those concerns, and as well as, you know, that legal opinion on what is allowed on the right-of-way and who has those rights. This board is not going to decide either of those things tonight, but we appreciate you coming forward.
Thank you, Mr. Curtis,
Thank
and the
you.
rest of you. Have a good night.
Thank you. Did anybody else have any other questions? Sorry, I didn't mean to. All right. So is there anybody else from the public that would like to speak? Okay. So we're going to set that aside. At this point, I think we need some definite, fill some holes for us, Mr. Bauer, Mr. Dvorak. How's that?
Okay, thank you, Mr. Chair. Again, I'm Mark Bauer. I'm here tonight representing Scott Dvorak, the Code Enforcement Officer, and I first want to sort of clarify sort of what's before you tonight. So what the ordinance says is what you have jurisdiction over for administrative appeals is to hear and decide where it is alleged there is an error in any order, requirement, decision, or determination made by the Code Enforcement Officer in the enforcement of this code. So what's before you tonight is a review of his denial of the building permit. That's all that's before you tonight. There's not a council decision that's before you tonight. There's not a town planner decision that's before you tonight. There's not a subdivision decision that's before you tonight. So that, I just want to make that clear from the outset, that what's before you is that permit denial that's in the packet that Scott issued in October.
And which attachment would that be? If you,
There's so many papers.
I think it's attachment 6. I just want to make sure
Yeah.
we're, okay.
Yeah, I was just going to run through the timeline a little
Yep,
bit because I
please.
think the timeline is important. So I'm going to go back to August where the town planner, Carol Ironman, reached out to my colleague Natalie Burns for an opinion on a contract zone issue, the contract zone that covers this property. So this parcel, normally would be in a different zone, but it's in a contract zone, just this parcel. And as you know, a contract zone is part of the zoning ordinance. It's just like any other zoning district, but it's subject to a contract with terms and conditions. So she wanted some guidance on that. And Natalie's response in the legal opinion was somewhat contrary to what the applicant's representative said. She said that the contract zoning agreement, and this is, I will make reference to, this is attachment 8B. It sort of copies and pastes Natalie's opinions towards the bottom of that, where it said the response is. So her opinion was that the contract zoning agreement is prescriptive and limits uses to what is permitted under that agreement. In other words, you don't look at the agreement and then also what the underlying zone is in that area. So this is the South Gorham Corridor District, Commercial Corridor District. You don't look to that, you look to the contract zone to what the uses are. And so what she said was, quote, here, that limits residential to anything in existence on the property at the time of the agreement or new dwelling units above the first floor of a mixed-use building. And so, as you know from the discussion, there is a home on the property currently, right on County Road, that was in existence prior to the contract zone. So that's allowed to continue in existence. It has a first floor, residential use. So what she's saying is that's allowed to continue, and that's also in the contract zoning agreement. It says right in it, permitted uses, residential uses in existence on the property on the date of this agreement. That's not in dispute. And then the second part of her opinion was that you cannot split off a lot and remove it from the contract zone, and in essence, to remove it from the restrictions of the contract zone without amending the contract zone or contract zoning agreement. So those were the sort of the two things. And there's another opinion later that I'll get to, and that was the first opinion that Natalie Burns issued. So then that was in October 21st of 24, and then October 21st, that same day, the town planner emailed the applicant, and she said, so it sounds like the lot division may work, but the tiny home wouldn't be able to be built yet until the contract zone language is amended. So that was sort of what her response back was. Then, skip ahead to, so the building permit application wasn't submitted until September 23rd, and that's that's referenced in the denial letter, the date of the building permit application. And it was filed for a single-family dwelling with 2 bedrooms. And then subsequent to that, the attorney for the applicant emailed Tom Poirier, and this is in the large packet of materials that I think starts on attachment, I think attachment 8A, but there's a lot of correspondence in here, and it's in towards the back of that. But what her attorney, the applicant's attorney, said was that cited the South Gorham Commercial Corridor District, which doesn't actually apply to this property. So that was part of the confusion, I think, was that he was talking about uses that can be permitted in that district, but that's not applicable here, as Natalie Burns had opined. It's the contract zone that you look to for the uses, not the underlying district that would be applicable if it weren't for the contract zone. He also makes reference to some home occupations, which is not a permitted use in the contract zoning agreement.
Sir, can I stop you for just a second and ask one clarification question?
Yeah.
So essentially what you're saying is, in the contract zone that covers this property, a first-floor dwelling is not allowed. First-floor mixed-use dwelling is not allowed.
Yeah,
But had they not been part of the contract zone, a first-floor dwelling would be allowed?
I'm not positive about that. It doesn't really matter, I guess.
Well, because it seems like that's what the opinion was, is that to
From her
remove a
attorney.
lot
Yeah.
from that contract zone would then allow that to happen.
Right, I think that's what they
Modify
wanted
it.
to do, but in order to do that, they needed to amend the contract zone to remove a lot.
Right.
So yes, just to clarify what the language, the key language in the contract zoning agreement, and I don't think it's really ambiguous at all. Residential dwelling units above the first floor as part of a mixed-use building is an allowed use in a permitted use in that contract zone. Residential dwelling units above the first floor as part of a mixed-use building. So that's kind of the key language. So then I think Tom Poirier had responded to the attorney saying that the lot in question does not have an approved commercial use or structure located on the property. But I think, really the key aspect to this was the proposal to have residential on a first floor, which is not something that the contract zone allows. Then on October 22nd is the second opinion from Natalie Burns, and I think this one may or may not be, it was referenced by the applicant's representative, but I don't know that it's actually in the record, so I was gonna, Scott, do you wanna just circulate these? And then, if the applicant needs one, there's one. So this is October 22nd, and this was in response to Scott's question to her. There was a follow-up discussion, and what she said, and again, contrary to what the applicant's representative was, and I'll just read this into the record. A question has been raised as to whether, and this is number 1 under her email, as to whether a ground-level single-family home can be constructed on a lot that has been divided from the original 15.69 acre parcel. Section 2 of the CZA, with the contract zoning agreement, establishes the permitted uses on the property. Subsection 1 authorizes residential uses in existence, or subsection I guess it is, authorizes residential uses in existence on April 4th, 2012. This covers the existing ground-level single-family structure. However, any new residential use must comply with Section 2K of the CZA. That requires dwelling units to be located, quote, above the first floor as part of a mixed-use building, end quote. This means that a new single-family dwelling cannot be constructed at ground level on any on any of the areas subject to the CZA, even if the original parcel has been or will be split. So that's sort of couldn't be more clear, what, in her opinion, to Scott, and Scott was asking for clarification on that. She provided that. Following that, the very next day, Scott issued his notice of denial, and it basically, followed along with that guidance from the attorney, from Natalie Burns. So that denial, which is in the record, like I said, basically just sort of mirrors that advice under the provisions of the contract zoning agreement for the property. Section 2K of permitted uses allows residential dwelling uses above the first floor as part of a mixed-use building. There were no exemptions listed in the agreement. Because this is a new proposed residential development, it must comply with the requirements of Section 2K. So that was the basis for the denial. And again, that's what's before you tonight. That denial of that permit, that letter stating why it was denied, that's what's before you tonight. 2 days later, the administrative appeal was filed. And so, and then following that, I think there was some further correspondence as the applicant's representative made reference to, and there was even an email, I think on October 31st, where the planning director, Tom Poirier, emailed the attorney, talking about maybe the possibility of an accessory dwelling unit on the parcel and other ideas of, other things that would be possible, but other than what's being proposed as a 2-bedroom, single-family dwelling with first floor residential. So that's kind of the timeline. I wanted to, obviously get that second legal opinion into the record. And so there are, as the applicant's representative said, there are 2, I think, relevant legal opinions related to this issue. And the second one is the one that really informed and the decision on the permit denial. So I just want to clarify again, sort of going through the points. This is an appeal of the CEO's permit denial. In my view, the CZA, the contract zoning agreement, is unambiguous on this point of what residential uses are allowed on the property. It's I'm not going to state it again, but it has to be on the first or above the first floor of a mixed-use building. It's got to be above it. The board has to apply the language of the zoning ordinance, which includes the contract zoning agreement, as it's written. It has to. That's your job. It's can't add language that's not there. You're obviously allowed to interpret it, but in my view, it's not ambiguous in terms of what's required there. You have to apply it the way it's written. The permit that was sought by the applicant clearly does not meet the requirement in the contract zoning agreement of residential above the first floor.
Is there, and I don't mean to interrupt, but
Yeah, no.
but clearly, and I'm not going to be the one that makes this determination, but the applicant has stated that there is some disability of the person who's going to live there. My experience generally is that state law, you can be more restrictive, but you can't be less restrictive, so to speak, right? So is there a state law, ADA, disability type thing that applies here that would be, it sounds like what the applicant is making the argument that this person can't live on a second floor. This person needs first floor access. And I'm trying to, in my own mind, I'm trying to weigh out the two things.
If I may.
Yeah, please.
And just to clarify the distinction
right.
between me and Mark too.
Right.
So I'm representing the board, Mark's representing the CEO, so.
Yeah.
What they've applied for is an appeal of the CEO's decision.
Right.
It is not a variance. A variance is not in front of you
Understood.
this evening. So that distinction may be relevant at a future
Right.
decision at a variance request from under the code, but they've applied for an appeal of an
Right,
administrative
understood.
decision. So
Yeah, I see my question kind of wandered is what you're basically,
well,
I appreciate that.
I get where you're going.
Yeah.
It's not necessarily relevant to your limited scope this evening.
Well, it helps with the understanding, they brought up the idea, and that's why the board may not want to, it's not where I went, but I look smarter by asking the question and
Fair enough.
then look dumb because you correct me. So how's that? And I'm happy to be both. So.
I didn't mean to interrupt Attorney Bowers
No.
on his presentation, but.
No, I think that helps clarify. Then the only other question I would have in the middle of your presentation is for Scott, and we can get to that
yeah.
after. So go-
Okay.
if you want to continue.
Yeah, I don't have much left. I just, just on the ADA piece, so this board does not have jurisdiction to decide whether there were an ADA violation or something like that. Obviously, the house, would need to be built to ADA standards, and there may be ways to do that, but that's not before you, and this board doesn't have jurisdiction to decide even if there were a violation of the ADA. You have to apply the ordinance as it's written. And again, there was a couple other points. This appeal is not about the proposed amendment to the contract zoning agreement that was made reference to. That's a legislative decision by the council, which is not before you. What's before you again is the CEO's decision. Whether or not the council decides to amend this contract zone will not ever come before you in terms of an appeal. So that's, that should not play its way into your decision-making process. The CEO has the authority to enforce the provisions of the zoning ordinance. That's clear as day, and I agree with the applicant's representative on that. The CEO is the one that made the decision in this case to deny the permit, and denied the permit based on the plain language of the contract zoning agreement. And then I just would add just one point on the idea that some work was done, sort of along the way here. But to the extent that work was done before a permit was issued, that in my view at least, that was done at the applicant's own risk. Until you get a permit, you don't know that that's going to be granted or not. So if they engage some consultants to do some looking at the property, in my view that was at their own risk. So and then you had a question for Scott.
I do. So, yeah, please go ahead.
I actually have a question for Attorney Bauer.
Yeah, please.
So I just want your position on this. I'm looking at attachment 7, which is the contract zoning agreement. I'm specifically looking on page 2 of 6 of that agreement, paragraph 2, and subparagraphs I and K. And I just want to know what your position on this is, because it would seem that paragraph I could be applicable. Residential uses in existence on the property on the date of this agreement. And my question is, does uses refer to a specific building, or does it refer to the common parlance of the word, which is use? And if your position is that the former interpretation is the one that we should apply, meaning that uses means a specific building, then why does the agreement specifically identify residential dwelling units in paragraph K, which obviously signifies a specific building?
Yeah, I think it wanted to call out the fact that there was a residential use on the property at the time it was adopted. So my opinion lines up with Natalie Burns' opinion on that, where she said subsection I authorizes residential uses in existence on April 4th, 2012, which is when the contract zoning agreement was adopted. So I think that the council wanted to call out that there was a house on there that would not comply otherwise, and that they're basically saying that that's a permitted use, in that's allowed to continue on. But then they added K, which is residential dwelling units, and so in my view, that's new ones are allowed as long as they're above the first floor and are part of a mixed-use building.
You would agree with me, though, that there's a difference between the word use and the word dwelling unit?
Yeah, no, absolutely, but it's because the property was being used for
Yeah,
residential purposes
but
at
it
the
could have
time.
said residential dwelling units in existence on the property on the date of this agreement, and it doesn't say that, right?
It says residential uses, yeah, because
Yeah, but it could have said dwelling units, right? But that's not the words that were chosen. The word that was chosen was use, which has a different legal meaning than dwelling unit.
Yeah, and again, my interpretation of that is that the property was being used at that time, and so that's why the council had used that term in the agreement. So that's.
So I've got their position, Brandon. I'm going to circle back to you when they're done presenting. I want your take on it.
Bring up a valid point. Scott, my question, and it probably doesn't mean a whole lot, but I'm curious, if the contract zone didn't exist, does the zone that they exist in outside of the contract zone, would it allow the first floor dwelling unit?
Like the underlying?
Yeah, whatever, I don't even know what zone that is. I mean,
That's, what is that?
and it's kind of pointless for me to ask the question, but I'm curious if it's, what I'm getting at, is it only the contract zone that modified it to the point where the argument is that a first floor unit?
I can answer because I just pulled
Please.
up the ordinance. So what it says, this is the South Gorham Commercial Corridor District, would be the underlying zone if there weren't a contract zone there. It allows 1 and 2 family dwellings as part of a mixed-use development only, and it allows residential dwelling units above the first floor as part of a mixed-use building.
All right, so,
But again, this is not in that
Right,
district.
no, okay,
It's
good.
not
Yeah,
applicable.
that's fine. So that's-
So we don't really need to go there.
Right.
So.
any other questions from the rest of the board for Mr. Bauer or Mr. Dvorak?
I do. When the town was making this opinion as to whether to grant or deny the building permit, and it was coming to a legal conclusion about what these words meant, did it look back at all as to what the town council passed and, you know, what the intent of the town council was when it chose this specific language?
Are you asking Scott that question?
I'm
On
asking,
the-
yeah, I mean, I'm asking
on the
both of you.
question of, I don't know whether, no, it's not here. I don't know whether she looked back at the minutes from the meeting or not, to be honest with you. I don't know, and Scott, I couldn't answer that.
So no one's prepared to present any evidence about what the town council intended when it chose those words?
No, and I think legislative history is useful to the extent that there's some ambiguity, or in what the courts have said is that you can look to legislative history and when there's some ambiguity. I don't think that the ordinance language is ambiguous in any way.
So assuming that I disagree with you, what would you tell me as to why I should interpret uses to mean the same thing as dwelling units?
Yeah, and I'll just say what I've already said before, is that the property was being used at the time that the contract zone was adopted for residential purposes on the first floor. And so it was memorializing that, saying that, I mean, otherwise what the provision of in K would have no meaning at all if you were to take the position that because there was a building with a first floor residential use, then it's allowed everywhere in that zone. The subsection K would be meaningless language.
Well, other than the fact that if you were going to use a mixed-use building, that the only place you'd allow residential use is on the second floor.
Yeah, I don't know that I agree with that conclusion, but I understand your position.
I may be able to help a little bit.
Please.
I don't know that the South Gorham Commercial Corridor District was in place at the time, but the way that the rest of the ordinance flows, it does distinguish or uses these terms somewhat broadly and then specifically. So if you look at the South Gorham Commercial Corridor District, which isn't applicable here, but as an example,
Sure.
it says permitted uses 1, residential uses, and then it lists those specific residential uses underneath them, which include residential dwelling units above the first floor as part of a mixed-use building.
Okay.
So taking a step back and looking at the contract zone language, residential uses, which could, and I can try to find the actual definition of residential uses if there is one, but I would interpret to mean anything that was in existence that was defined at the time as a residential use. It could have been multiple things. And then in addition, it's allowing, under a residential use specifically, residential dwelling units above the first floor as part of a mixed-use building, as compared to in the South Gorham Corridor District, for example, nursing homes or homes for the aged, manufactured housing units, apartment buildings, accessory apartments. So I think anything that might have been a residential use on the date of the agreement, it just so happened that it was a single-family home, but it's all encompassing, and then it gets more specific to say residential dwelling units.
So is the use tied to the existing structure that was in place at that time? Or, let's say you had a single-family home and you wanted to tear that one down and build a single one, and there's still one single-family home on the plot, on the lot. Has the use actually changed, right? I guess that's what I'm saying, is use equivalent to structure?
I think it could, yes, I think in the short answer is yes. If they wanted multiple residential uses on new structures, it would have to comply with the rest of it. If they want, and I think it's somewhat irrelevant, if they came in and wanted to tear down and replace like for like, I think that would be a residential use in the same sort of footprint as existing on 2012. But to separate it or to subdivide into 2 units and build a new structure, it would need to be one of the allowed uses. A funeral home, daycare, business, personal repair, convenience store, residential dwelling units above the first floor.
Okay.
That one's a little difficult for me in the sense that, because I feel like I understand where you're coming from on that, Pavel, is that it specifically states that there were residential uses in existence on the property at the date of the agreement. And my experience on this board is generally that those uses are not tied to a structure, that they're tied to a property. Like, once the property is a residential property, or the property is a mixed-use property, or the property is a commercial property, or the property, it's an auto sales, we don't say auto sales is confined to the one building that's on the front left corner of the lot. We say that the property is permitted, right? And
It's I think you're getting into a grandfathering question at that point of.
well,
it would be a
that's probably been
non-conforming-
my experience.
It'd be a non-conforming, potentially non-conforming, if they tried to expand it significantly, if it wasn't natural, you're getting into some.
Sure.
But see, this is where I'm struggling with this, because where do we draw the line, right? You said if you built you tear the house down, you build a new house on the same site, it's the same residential use. So why is that different from taking that house and moving it 20 feet to the left?
Potentially. I said potentially. That's where you get into the grandfathering and the expansion, and it's a different analysis that you're looking at.
So there is at least a lawful interpretation of this contract zone agreement, whether or not it's the predominant interpretation that would allow this individual to build this structure.
It is the duty of this board to review the contract zone language
Yep.
and make its interpretation on
Well,
whether or not the application that was submitted was rightfully denied by the CEO or not. So the single-family dwelling, in addition to what's already in existence, that was applied for, does that meet the permitted uses under the code?
And one of the things I think about is risk, right? So what risk am I exposing the town to by making a decision one way or another? And I guess as the counsel for the board, my question for you would be, is the interpretation that I propose that there is a definite distinction between the word uses and residential dwelling units, is that an interpretation that would expose the town to significant legal risk in a subsequent lawsuit?
There's risk.
Okay. There's always risk.
There's always
risk, right? I get it. I deal with this stance too.
You would need, if that is the direction the board chose to go, what you're looking at is the denial letter, which is Exhibit 6, and articulating clearly why you feel as though, based on, and I think it's mostly in the last paragraph at the bottom of page 1 to the top of page 2, why it does meet the contract zoning agreement.
While you're contemplating that, Scott, we heard testimony from the applicant's representative that at some point through this process, it seemed like you were prepared to issue a building permit. Would you say that was a proper characterization of where you were in your thought process until you?
I'm always willing to issue a permit if
Yeah,
it,
yeah, just want to make sure you caption that.
I'm always willing to issue a permit if it meets the standards and the
Yep.
requirements of the zone that it's in.
So, were you ready to issue a permit and then presented with additional information or something that changed your opinion? Or were you still contemplating the whole thing until you got to the denial letter?
No, I,
I mean, I kind of want to, I'm sorry to put you on the spot, but I'm trying to figure out whether or not the,
well,
You know,
I don't know if you have it in your packets or not, but I had an email dated October 15th. That was my first response after there was an interpretation from the first question answer from Natalie, the first reply.
okay,
And basically, my email is, I did not see this email till Chris Wood brought it to my attention. After I tried to look at the window well, which she was putting on her existing house that is there. So they asked, so to answer the last question that was asked, this is a quote, so as long as they keep the business out back, they can add a small house to it, and the house would not need to be on the single floor, end quote. My response was, permitted uses that pertain to your question in the letter K and the letter I, a residential dwelling must be located on the second floor of a mixed-use building. There is no exception that I could find that would allow you to build a residential unit on the first floor. The existing dwelling is the only residential unit that existed, and by splitting the lot out, the new lot must follow the permitted uses listed. Any new lot split within the contract zone must meet the requirements of the contract zone. Currently, we do not have a site plan for a commercial use within the contract zone. The permitted uses for your contract zone are as follows, which are the ones that are on the
That are already quoted.
contract zone.
Yep.
That was my first response.
That's attachment 8E, by the way.
yep, thank you. Other questions from the board?
I have some questions for Mr. Shane.
There you go. Mr. Shane?
Mr. Shane, so you just heard Scott's response to the questions. When were you informed that, and how were you informed that this was going to be approved, which is what you've told us you understood?
Yeah, I didn't hear that last part.
When and how were you informed that this building permit was going to be approved?
Was not going to be issued?
Was going.
Was going to be approved, so you
Oh,
told us.
all along it was going to, Scott was in the loop from day one. We're very transparent. This is what she wants to do out back. He told her what she had to do. The garage would have to come down because it would be in the way of the right-of-way going to the back. She could still use the garage in the back, which she was already using for her business. He inspected the ADU unit. That's why it was, that's why I say there's too many cooks in the kitchen. The letter from Tom Poria and then subsequent to Scott says, oh, you can do it if it's an ADU. She already has an ADU. And it's on a different lot now because she sold the house. So now she has sold the house. Okay, so anyway, she tore all that down. Tore down the garage, kept the garage in the back that's been used all along for the business, at least the last 20 or 25 years. Where was I going with that?
So my question, I guess, is there a document or an email or something, and I'll be honest, I didn't see anything in the materials that were provided to us, where you or anyone else was told that.
I think most of it was just communication with Scott.
So
She
what-
dropped off the permits. He called her and said, you need to supply the surveys. So she got those done, the deeds, supplied those to him. At one point, she called looking, and Chrissy, correct me if I'm wrong, looking for the permit. And the girl said, it's all written, waiting for Scott to come in, whatever. Scott came in, she called Scott. Scott said, yeah, I should have it ready in a couple of days.
Hold on right there for just a second.
Septic design, I dropped that off.
Okay, so, because you're not at the microphone, I want to capture all that. So if you can just tell, Susan will say it on the microphone, or the applicant saying that you just needed a septic design, and then you drop that off,
Right, he didn't have a copy of it, yeah.
and a cost for the house. Okay, so I'm going to stop there for a second. I just want to see if the general characterization of those conversations ring a bell, or would you, I mean,
So the cost of the house was a question that, and a new plot plan was asked after the meeting with Tom Poirier, Chris and Susan and their attorney about applying for an ADU on that property.
okay.
To all clarity, I had forgotten that we had just recently issued a occupancy permit for an ADU on that existing house,
Okay.
which would have been brought up had I remembered at that meeting.
So essentially, you're allowed one ADU per, and so this would have gone beyond the allowed number of ADUs? Is that, okay.
Then it was October 31st. This is after the meeting. This is when I asked that I needed the estimated construction costs so I can calculate the fee. This was October 31st. I also needed an updated site plan showing the ADU is on the same lot as the existing house. The lot plan that was submitted when the lot was being split, and the other thing we need is a signature on the permit. Both the signature and the plot plan can be done at pickup. Once I have the estimate, I can compute the
already
fee,
paid
and
for
then
the
I will
other
call you to
permits?
let you know your permit is ready for pickup. Please be aware, because the ADU is not attached to an existing house, the ADU would need to be sprinkled.
Usually you pay them all together.
Because of timing, you don't need to submit a sprinkler plan at this time. You pick up the permit.
Why had he
Okay,
already given
so,
you a price on the
just,
permit?
so my understanding is correct
No,
here.
on the other permit.
Essentially, all of that was done and written, and I'm not trying to call you out here, Scott, I mean, we all, a lot going on, you know, but essentially, at that point, you hadn't sat down and really looked at the plot plan of the property to see that there was already, like, when you pull the folder out, eventually, I mean, at some point, you're reminded that there's already an existing ADU, and then that sparks your thought process that, hey, wait a minute, we can't have more than one ADU on that lot, is that?
Well, yeah, I mean, the ADU has to exist with a single-family home. My understanding would be that they were redrawing merge the two lots back together again so that the single-family home would stay on the lot with the existing house. Again, forgetting that there was already an existing ADU
Okay.
already on the property.
To be clear, this all occurred after the permit denial, so it's really not relevant to the discussion.
Well, I'm just trying to get the timeline, and to me, if it is, if
After,
the
it was
timeline is
the
that,
31st
I
of
mean, I'm just
October.
trying to,
Yeah. No, I understand.
getting
but-
one thing here and one thing there, and I'm trying to make a mesh up so that I can
just want to
understand.
clarify that email that he was just reading from occurred after the permit was already denied, you know, so.
Right, but it
that's-
sounds like there was a meeting to get to, okay, so the permit's denied, there's a meeting, they sit down,
It was after the appeal was filed as well.
okay, well, filed but not noticed to us or whatever, right?
But it was,
but
they'd already appealed the decision.
they've dropped that off and asked for an appeal. Yeah. Okay, so if you would like to go to the microphone and just if,
Yeah, I'm going to let Chrissy talk, but what I do want to say is this was ongoing communication. Mark Bauer was not there.
Right, no, and
Scott
I-
actually goes to work every day without Mark Bauer.
right, and I understand, hang on just a sec, because I'm trying to get, and I will definitely give you guys your opportunity here, but I'm trying to get to that point, because I tend to, so there was a denial, and then there was a meeting, Scott, right? And then at that meeting, it's you, the town manager, Tom Poirier, the,
Manager wasn't there.
this wasn't the meeting the town manager was at. Okay, so you, Tom Poirier,
Yes,
the applicant, Susan,
yep, and their attorney.
and their attorney. Okay, and what I'm gathering at this point is that everybody's trying to work through and figure out what's needed. So even though you've issued a denial, it sounds like everybody sat down and tried to come up with, okay, what do we got to do to make this happen? You gave them some guidance, and it sounds to me like in somewhat of an error, and I'm not trying to call you out, we all make mistakes, to err is human, as they say, But you gave them some advice that essentially if you can do these things, we should be able to get to a permit. And then at some point between that meeting and a time a little bit further in the future, you realized, wait a minute, I can't do that because there's already an ADU. Is that true? Is that?
In a way, yes, but I also, when they were going after the ADU, I looked at the ADU standards, which requires it being on a single-family home, and knowing that originally they were going to, original plan was that the existing house was split off. So once I figured out on the ADU, yes, then you have to meet those standards.
Okay.
That's why I asked for the new site plan.
But again, I just want to point out, this occurred after the denial, so it really should not play into the decision-making process at all, because what you're looking at is, on the date of the denial, was that proper or not? Not sort of what happened after that. They could have had other discussions and that
Agreed.
kind of thing.
Understood. I'm just trying to square, like, for me, I was trying to get the timeline, and I didn't understand that the criteria that they were given to possibly get a permit came after the denial. I didn't understand that myself. So that now, would you, is
Yeah,
that?
so let me explain that. So during this whole process, and we're working with Scott to get, this permit, we break the lots apart. She does her septic design. We do everything. So she spent, I don't know, 20 grand, somewhere in there. So that's all been done. Then Scott tells me that he met with Tom and that Tom didn't agree with him and that Tom wanted him to give a denial letter. And I said, what are you talking about? Why would you deny it?
This is before you ever, before anybody received
Before
the
the denial letter.
Okay, all right.
Verbally, Scott told me that Tom has told them they all need to agree, everybody needs to agree, and we all need, and I explained to Scott, you're the code officer, what does Tom have to do with it? Well, my hands are tied.
Well, I think we heard from the attorney, and I think the attorney on the other end of the table and you all agree that in the ordinance, the code enforcement officer has the authority. I don't think anybody's disputing that. Is that right?
Correct, but he wasn't given that because he was overridden by Tom. Then he wrote the denial letter. That's when we asked for the meeting. We go to the meeting, and again, Tom comes back with some letter saying, okay, well, you can do an ADU. We already have an ADU, and they're already separated lots. We'd already gone through all these steps with Scott prior to any denial letter, any meeting with Tom. And for Mr. Bauer, I mean, the only thing worse than all the cooks in the kitchen is all the lawyers in the room, because he's speaking wrong. Never did we talk about the house in the front. Natalie Burns is very qualified. Don't always agree with her, but I respect her opinion. She knows she wasn't talking about the house in the front could be on the first floor. Why do we need a building permit for the house in the front? It was already built. So, I mean, that's just, Scott's capable of speaking for himself. We're just coming up with legal reasons why Scott might have done something. So he didn't do it the way he might have. Maybe he did it wrong, maybe he did it right. I don't know. But the bottom line is, who paid the price? She did. So that's all we're trying to fix here. So she doesn't own a property now. She divided the other lots accordingly under Scott's supervision and direction and was provided them. They're all recorded. She took her homestead exemption for the front lot. She made a lot in the back, and that's legal without creating subdivision. And the remaining land, still not creating subdivision. And that will go later on. But to say anything about the house in the front or another ADU, Scott was out there telling, he approved her bulkhead that she put in to make the ADU compliant. So, and then, like I said, Tom's writing letters, oh yeah, you can have an ADU, you can have this, you can have that. It was just ridiculous.
All right, so,
Scott's secretary, Teresa, not his woman, sorry. Scott's secretary, Teresa, called me and told me to come pick up the permit for the septic design.
And add $250 for the septic.
$250 to bring a check and bring it up. And then she called me, I think it was the next morning, and said, Scott told me to hold off, he's got to check with Tom.
okay, understood. Appreciate that information. And I don't want to go back and forth with the he said, she said by any means. But I also don't want, I mean, Scott, if you're sitting right here, and I can tell you 100%, if Tom was here, I'd be asking him some of these questions as well. But, I mean, the notice of denial is signed by you. Is that notice of denial your opinion?
Yes.
Okay. So whether somebody helped you arrive at that opinion or not, or who you talked to, I don't know that it necessarily, all I want to know is that you are the code enforcement officer, you signed that letter of your own free will, and using your authority as the code enforcement officer. Is that?
Yes.
Okay. So as much as I hear what you're saying about that, the letter is signed by the code officer. And if he had a previous opinion that more aligned with yours, that's not in writing. I don't see, I don't see that in writing. What I see in writing is the denial at this point.
He should have his own emails that he sent me stating that what's the cost of the house, you can come pick up your permit, as long as I have these items. Those were things that he wrote to me prior to the meeting.
All right. So,
The other thing.
but I think what we've established on the timeline, and I'm sorry to belabor this point, is that we have the notice of denial, then we have a meeting. So the
The letter he sent me that said he had to,
The permit was all ready. I think he
Correct.
called you
Okay.
on that.
called me on the permit.
She could pick up the permit, say, 2 days from now.
All right, hang on 2 seconds. Scott, was there a time prior to the notice of denial that you were ready to issue the permit?
Well, I would say, first of all, it wasn't deemed complete yet because I had no signature.
Sure.
And had no, so technically I couldn't even start my review until then.
Right, but you're trying to be efficient and trying to be timely.
Yeah, I
Right.
mean, yeah, I do fly, sometimes you fly a little bit. That, if everything goes right, yes, I would be ready to issue the permit.
Okay. All right, so I kind of want to step away from that. I just wanted to clarify that timeline. I don't think we need to spend a lot of time on it because there's not a lot for us to do. I mean, in your appeal, when you made your presentation, part of what you were trying to make the point of is that Tom doesn't have the authority, Tom Poirier, who's the planning director, I believe, or code, and Scott does have the authority. I don't think anybody disagrees with that. I don't think there's anything part of this appeal. I think we all agree that Scott has the authority. Is there anybody, any of the attorneys, Scott, anybody else that doesn't agree with that statement? Okay, so I don't think that this board has the authority to necessarily decide it unless we were looking at a letter that Tom and Scott were disagreeing and which one we were supposed to use.
Right, so I'm not sure if Scott understood exactly what you just said, because if he did, then I'm really confused. But just so you know, and on a side note, and I just want to say this while I'm on public, anything we got from the town, we were told we had to file a freedom of information. I wasn't even allowed to have Natalie's opinion without filing a freedom of information on an email that came 2 days earlier. Somebody couldn't just print it off for me. So anyway, Scott and I talked directly prior to that denial letter, and he told me he needed her to stop by and sign it and get him a cost of construction, then he could sign off on the permit. He specifically told me Tom Poirier is the one who told him he could not issue the permit. Okay. So I don't think Scott understood that, because I don't think he would tell me one thing and you another. So you might want to ask that question again, because it didn't come from from Scott's direction, it came from Tom's direction.
I don't,
For
Yeah,
clarification.
please, yeah.
Was there ever a permit issued?
We were told it could be picked up, yes.
He told it could be picked up.
And then we were called
Yeah.
back and said, you can't, because Tom said no.
Right.
Okay,
I was
so you-
told to come pick up, pay for the septic design, it would be $250, come down and get it. And she called me the very next morning and said, you can't pick it up now.
So you never got a building permit?
No, but we the lots were
I know there
divided.
was a lot of conversation,
Not getting
but
picked up
there's
on the
no
record.
permit.
Oh, I'm sorry.
If whoever speaks, just make sure you speak into the mic.
Okay, Mr. Sterling, did that answer your question?
Yes.
Okay, all right, thank you. All right, so although it seems like there's 4 pieces to this, I mean, we're really down to the appeal is essentially an administrative appeal. Do we agree with the opinion of the code enforcement officer, which seems like it had some input, or do we think that, as Pavel has pointed out, that maybe there's some ambiguity or maybe some rights that are not necessarily considered by those who gave the opinion? So I guess that's what it really boils down to. As much as
It's really a single issue.
Right.
It's
right, it's not four issues in as much as it's the single issue in my opinion, and I'm more than happy to hear from anybody else. But it's essentially, do we want this notice of denial to stand? Do we agree that it was done correctly, or is there additional information that we've been given that would lead us to believe that an alternate decision should be made?
Yeah, so, and just, Ms. DeShane, for your benefit, our scope is very limited under the Land Use and Development Code. So if you look at the Gorhamtown ordinances, you look at the LUDC section 1.1-4B, the Board of Appeals has only the powers and duties that are in there. And so for the purposes of an administrative appeal, which is what this is, we have the power and duty to hear and decide where it is alleged there is an error in any order, requirement, decision, or determination made by the code enforcement officer. And there's a whole bunch of like clarifications and exceptions that you can read on your own time that aren't relevant here, but that's really all we can do. So I know there's a lot of questions you had, but I think that's all we can address tonight.
Okay, so I guess what I would ask the chairman is if you can ask Scott, because I think he misunderstood the question you asked.
Okay.
Was it his opinion that he couldn't no longer issue the permit, or was it Tom's direction to him?
Happy to ask that question. As the code enforcement officer.
And I'll just start, it doesn't matter. What's before you is the decision, the written decision with the reasoning why the permit was denied, who had input on that, whether it was the town attorney, the town planner, it was his decision.
Well, it does matter.
And you have to decide whether that was right or wrong.
It does matter,
your job
because you
tonight.
just determined.
Right. I understand what you're saying, and I guess if anybody on the board wants to stop me from asking the question, I think essentially the applicant, I don't know if you'd call it an accusation, but she's made a statement that this opinion is not Scott's. I think I asked that question already, and I think anybody who does business in this town needs to know that the code enforcement officer, as called out in the ordinance, has the authority to issue these decisions. Now, he could make a mistake. I mean, it's entirely possible. But I think the bigger question is the code enforcement officer making these decisions, or is he being forced to put his name on something that is not his decision? And I think, is that essentially what you're concerned about?
That's exactly what I'm asking.
Okay. So I think it's a legitimate question. I mean, if somebody wants to stop me from asking the question, please stand up and say so. But I know when I do business in any town, I want to know who I'm dealing with and who has the authority, and again, I think that there's plenty of opportunity for plenty of people to weigh in, but in the end, Scott signed this, and I thought I asked the question, I thought he answered it, and I thought he did a good job at it. Scott, after gathering all the information, the notice of denial has your name on it as signed. Is this your opinion, or did somebody else in this building, or somebody beyond this building, make you give this opinion that you didn't want to give?
I wrote that denial by myself with no interjection from anyone else when I wrote that letter.
Okay. Does that answer your question? I mean, I know it's maybe not the answer you're looking for, but that's...
Scott, you came right out and told me he was
Okay.
your boss, and you had to do what you were told to do.
All right, thank you. Thank you.
I think it's time for the board to deliberate.
I agree. So we do have, I think the attorneys have both boiled it down fairly well. I think the decision in front of this board is whether or not this denial was the proper decision, or if there was an error in this decision. And I think that I would entertain any discussion one way or another. Anybody have a...
For me, it's probably a closer call than it's been characterized. You know, we're looking at a contract zone agreement that has the word uses, that is not a defined term within the agreement. I understand your point, Brad, that it's defined in other sections of the ordinance that weren't maybe passed or in effect at the time this contract zone was entered into. And so they may be indicative of the intent, but I think that the question kind of for me hinges on whether uses is a term of art that refers to structures, or whether uses is a term that should be taken at its plain language, which just means methods of using, how we use a property. And I think we need to decide, you know, where we draw the line on what is a change in use. And so that's what I'm wrestling with. I've not made a decision, but it's what I'm going through my head on.
Do you think it would be appropriate to ask Mr. Dvorak if he considered that thought process as he applied his decision, or?
I actually think that might be helpful because it's not mentioned in the denial.
Okay, so let's see, I gotta find the uses.
So I'm looking at attachment 7, page 2 of 6, paragraph 2I.
Trying to find my copy of that.
You cite to 2K, but not to this one.
No, the ZBA, I mean the contract zone listed uses. Okay, I found it, never mind. So, as far as I am, is that what you're asking?
Yeah, correct.
Okay.
Did you consider that, and what is your opinion on that?
I interpret it as the residential uses in existence, which would be the existing single-family home,
Okay.
okay? That it's on the property of the agreement, which to me tells me that they're calling out the existing single-family home only at that point.
And why is that? So I guess why, help walk me, who's not a code enforcement officer.
Well, first, they're asking, again, residential uses, which would be a single-family home.
Sure.
There is a single-family home there, which exists. So to me, the single-family use that exists is that single-family home that is there. Doesn't mean anything in the future or what's allowed. They're calling out that specific structure as a residential use, to me.
Okay.
A 2-unit or a 10-unit,
Whatever that
residential would
was.
also be
It
residential.
says that the property at the date of the agreement.
Right.
So what existed at that date of the agreement? The single-family structure, single-family home was the only thing that existed for a residential use at that time.
So, thank you for that, Scott. Permitted uses, I mean, in the contract zone, the property owner is authorized to establish on the property any of the following uses without additional town council authorization. It's the first line. And then it lists them. And I think the argument that you're making, Pavel, is that, again, I don't know if you're really arguing for it, but arguing for it to be considered here is that residential uses of the type that are already in existence, so a single-family home is in existence on the property. You're not arguing that she has the right to put in a 10-unit without asking anybody's permission. What you're saying is there is a residential use on the property, so that grants her the ability to have a residential use on that property. It's, as Scott said, at the time, it was a single-family residential use. So, I mean, I think you could make the argument. I'm not saying Scott's wrong. I'm just saying that there is, that's where our decision.
And that is,
Right.
I mean, you distilled my line of thinking on this very clearly. You know, it's the property owner, so I'm looking at, you know, the first line of paragraph 2, permitted uses. The property owner is authorized to establish on the property any of the following uses. You know, again, it would be redundant to establish a residential use that already exists.
Well, and I've drafted a number of contract zones. What you want to avoid, though, also is creating a non-conforming use within the contract zone.
Sure.
So you need to allow what's already there. Otherwise, you would be creating an ambiguity or a non-conforming use. And the whole point of contract zoning is to clean up some of that and to make sure that what's there is there into the future and what additional things may be allowed.
Absolutely, but you could put a paragraph that says, residential units in existence shall be a conforming use within the purposes of this contract zone without using the verb to establish. There's a drafting way to get there without drafting it with the to establish verb, right? So
what could have happened here is there may be a mistake in the drafting, but again, as both attorneys have said, we have to consider the language that's here, not language that we wish was here.
Exactly. I mean, we're really, that's just really pushing it to me. The one word, residential uses, could it have been a better word? Yeah, possibly. But to me, that refers to what is there on the date of this agreement, nothing else. It's just referencing that structure. The contract zone is an agreement that was executed on a day. It permits these other uses, and K indicates very clearly further residential dwelling units above the first floor as part of a mixed-use building. I mean, this isn't about people. This is about the language in an agreement that exists. And yeah, I can't go with uses could have been this or meant that. It references a residential something that was there on the date the agreement was signed by all parties.
Thank you.
Mr. Chairman, with all due respect, I agree with Mr. Sterling 100%. We can sit here and make a wish list of what should be or could have been in this contract zone, but that's not what we're here to do tonight.
Understood.
Yeah, I think we've got to deal with whether we like it or not. It might be a bitter pill to swallow, but this is the way the contract zone is written. This is what the owner of the property agreed to at the time, and I don't think that it's incumbent upon us to rewrite it here tonight.
Understood. I just have a question for Brad.
Brandon.
Brendan, sorry. Brandon.
Yeah.
Okay. I'm gonna make my note change here so I get it right the next time. It seemed like the applicant has tried to go through a process and get to the town council. Now, you said you've written plenty of these contract zoning amendments. It seems obvious to me that the town council in this town has the authority to make any change to this it deems necessary. I mean, is there anything that would prevent a change?
No, in fact, I recently went through an amendment process to a contract zone here in Gorham. It's a process. It's like changing the zoning ordinance.
Sure.
You go to
It's not easy.
the planning board. They make a recommendation to the council. Sometimes the council will see it first. And then that amendment can be applicable. It could also, if it works into our plans, which it may not with the underlying, you could also petition to terminate the contract zone.
Right, if the zone, sometimes that happens.
And then it
You're a
reverts.
leader, the contract zone changes, and then all of a sudden, they change the entire zone, and then the contract zone is no longer needed.
Or that they can
Revert to-
terminate
yeah, okay.
with agreement from the town.
All right, so, again, I don't think that's a decision that's in front of us, but I also feel like there's an avenue in a direction.
Fine discussion, wrong venue.
Right. So is there further question of the applicant, the attorneys, the code enforcement officer, or do we have a motion at this point?
And I guess the question I have for the board is, I know you guys just voted on drafting, reviewing it. So our timeline, and I'm just anticipating the holidays here. If you take a vote tonight as opposed to tabling, we have 7 days to issue the written findings. That includes Christmas Eve and Christmas. So we would need you to all review it and approve it and have it issued by the day after Christmas.
Or,
Or we table, we close the public hearing portion of tonight, table to a date certain, it can be your next meeting. I will have the draft findings for you all to review that evening. We can either tweak them or not there, and then you take the vote then. And we can schedule that as a date certain if people want to look at their calendars, or we can just, you have your schedule, so we can schedule for that night. It'll give me more time to try to, I've been writing things as we've been going and trying to get it all cleaned up. But I can certainly make the commitment to try to get it to you by Monday, but that gives you, assuming people do not want to do this on Christmas Eve or Christmas Day, that gives you basically Monday to review it, and you'll have to come in Thursday, because Town Hall will be closed to sign it, assuming there's no changes. So I'm happy to make that commitment to get it to you all by Monday, but
I would prefer to vote now for two reasons. Number one is everybody's here tonight and everybody's come out, and these folks have been waiting a long time. Number two is I would like to vote on this, and on January 16th, 2025, I will be on military orders and unavailable, so.
that's my preference as well. I think any further delay is, just, and I know that puts a particular,
as long as I can clean this up and have it to you guys by Monday. It's just a matter of, normally I wouldn't have concerns. It's just you have Christmas Eve and Christmas Day in that middle part, so.
if it comes out to us and there's no changes, I can easily be here Thursday to sign it. So
Okay.
whatever it is.
So I think the motion that would be is a motion to sorry, I always do motions in the affirmative, so it's motion to approve the application for administrative appeal.
Which would reverse the denial letter.
Correct. So if you approve the appeal, you'll be reversing the denial letter. So if you want to uphold the denial letter, vote in the negative.
Okay.
I'll make the motion.
We have a motion. Do we have a second?
I'll second.
We have a second from Dan.
Sorry, who's second? Dan?
Dan, yeah.
Thank you.
Any discussion?
Yes. I am going to vote to approve the appeal. And the reason I'm going to vote to approve the appeal is I believe that there is an ambiguity in paragraph 2 between the future tense used in the first paragraph, the use of the word uses in subparagraph I, and the use of the word dwelling units in subparagraph K. And I believe that it's a fairly accepted canon of contract interpretation in the state of Maine that where there is an ambiguity in a contract, it is interpreted against the contract drafter. There's no language I can see anywhere in this contract that anybody else had any hand in drafting this contract other than the town. And so where the town has drafted this in a way that allows a different interpretation using just plain language, I think that the town is stuck with that. So I will be voting to allow the appeal.
Thank you. Any other discussion? The only thing I'll add to that is, nobody ever likes these, when you're on the Board of Appeals, you're either, nobody wants to go against the code officer, you want to back him up where you can, but you also don't want to go against the applicant. You know what I mean? The applicant is a taxpayer in the town. I don't think there's really a winner in this situation. I think what this means is that there's some work to be done no matter which way we vote tonight. I tend to agree in the simplest term, tie goes to the runner in this situation. And I can assure you that's how I'll vote. And it's not because I think Scott's done a bad job. I think Scott's done an excellent job in a tough position. He's handed a bunch of paperwork, but he's got to try to interpret and try to uphold every portion of this. And I don't want anybody to take my vote as a as a vote against what Scott did by any means, because I have an immense amount of confidence in Scott and doing what he does, and I hope to support him for a long time. Susan, we're not going to go back and forth. We're in our own contemplations here. So, any further discussion? All those in favor? 2. All those opposed? 2, 3, 4. The motion fails. So therefore, the denial letter is upheld.
Denial letter stands, is that what you're saying?
Yes.
Okay.
And denial stands.
Okay,
I understand. Thank you.
yeah.
All right. Is there, actually, step back to the podium. So let's capture the conversation. I think we clarified that really the only thing that is a full appeal, and I would be happy to discuss that a little further, was the denial letter itself. I think by a matter of course and discussion, we've established that Scott, as the code enforcement officer, has the authority, that Tom doesn't have the authority. And not, I mean, I'm sure Tom has plenty
But
of...
Tom did have the authority tonight, which is too bad.
Well,
but-
he didn't, because the letter is, Scott has already testified that the letter
did.
was
Yeah, he did.
written by him and signed by him. I mean, if I had a letter from Tom, I would agree with you that we would need to decide, or we may need to weigh in on that. Was there something else further? I don't want to miss the opportunity to decide something that has weight, that is within our purview. So was there something else?
I think the only thing was that fourth one, which was, I don't know exactly how we,
My note on the fourth one was essentially that the council has the authority to make changes to the comprehensive plan. And I don't think anybody has, what's that?
To the contract.
Excuse, contract zone. They of course can change the comprehensive plan, but that's an entirely different process. You do not want to go through that one. So the contract zone can be amended by the town council. I think, and it says that right in the...
And those are just clarifications. There's nothing there's
Right.
the 2 threshold questions before you even, and this is prefacing a discussion we have to have on the next
Please.
application. 2 threshold questions before you open up an appeal is right title and interest for standing. So the applicant had to provide, and that's why we got the deed for the record to show that they had the right title and interest. And then you have to have jurisdiction in order to rule.
Right.
The only thing this board has jurisdiction over was the appeal denial.
Right.
What the town council does, what anything else happens is beyond the scope of this
Can't make
board.
them do anything, right? So I guess I believe, and I think we've established that in the document itself, it says the town council can make those changes. I don't know what the process is, and I don't know...
well, I know, but the ordinance also says the code enforcement officer makes the decisions, and that's
Which
not
we've
happening.
got the
so-
decision, so thank you, Mr. Shane. Yep. All right. You have all the notes that you need?
I think I've got all the notes. I'll
Okay,
watch video if I have to, but I think I've got everything I need to
excellent.
draft an opinion by Monday.
Before we take up the next appeal,
Expected.
does anybody need a 2-minute break, 5-minute break?
Yep, I move 5-minute break.
Okay. Second. Thank you. So moved. We'll take a 5-minute recess. It's 8:19. We'll be back at 8:24. All right, welcome back. So the next appeal that we will hear is, or discuss, is Appeal 2404, Administrative Appeal from Carol Mulker, property owner and petitioner, is seeking an administrative appeal for map 108, lot 8, zoned urban residential. Before we step into that, there are two things that we need to deal with. The first is, I want to disclose to the board that, I guess I get around a little bit, but the company that I work for is currently working for the general contractor on Ms. Mulker's lot. So whatever the board's pleasure is, I mean, I always feel like I'm able to make a non-biased decision, but I think this is, of all the times I've ever been brought something like this forward, this is the closest one I've ever had. I've definitely met Ms. Mulker, I've talked to her, we still have work left to do at her house. So whatever the board decides, I'm happy to step away.
And I also know one of the abutters.
Okay.
so.
All right. So you want to elaborate on that? Is that, okay. So are you, let's stick with mine for a second and then we'll go right to yours. So what is the board's, like I said, I'm happy to step away. Court can run this meeting from this point forward. Or if the board is okay, I'll stay and walk through it.
Personally, Mark, I have no problem with that. I think that you can make an objective decision, and so I have no problem with you staying involved.
Thank you.
I
Greg?
concur.
Okay. Great. Yep.
I'm good with it.
I don't see any problems with it.
All right. So that's fine. So you know one of the abutters?
Yes.
I guess the question really comes down to this. Do you think you can make a
Yes,
independent
it's just on
decision?
a social,
Okay.
you know,
Perfect.
just want to make it clear.
All right, so that's the first part. The second part is whether or not we actually have the authority to address this particular subject. So at this point, I'd like to hand it to Brandon to bring that discussion forward.
Yeah, as I alluded to at the end of the, the last item, there are two threshold questions before this board can take up an item. One is, does the applicant have right, title, and interest, which would give them standing to be in front of that board? There's no issue there. One of the other findings and conclusions is that this board has jurisdiction. So my recommendation to the board is we break this into two parts and give the applicant the opportunity to address the jurisdiction issue, because at this point, under, and this came up in the last, under the powers and duties of 1-4B1, this is an administrative appeal again, this board has the ability to hear and decide where it is alleged there's an error in any order, requirement, decision, or determination made by the code enforcement officer in the enforcement of this code, except for, and I would draw your attention to B, decisions or determinations by the code enforcement officer not to undertake an enforcement action shall not be appealable to the Board of Appeals. There's no notice of violation. There's nothing in front of this board that falls in A or B that, in my opinion, shows jurisdiction, but I think it should be prudent on the, and it typically is, it's normally a pretty straightforward issue, but I think it's perfectly reasonable to let the applicant address that issue to point us in a direction that maybe I missed on the jurisdictional issue, allow the public to comment on that narrow issue before we get to the merits of the administrative appeal itself.
So I can see that Ms. Mulker's at the podium. Do you understand the quandary that we're in right now is that essentially the code enforcement officer has not issued a decision that is appealable to this board that we understand, but we'd absolutely grant you the opportunity to articulate what it is that you're trying to appeal, and then we can make that decision.
I think you'll understand after I make my statement.
Okay?
I would just caution you to not get into the merits of the appeal. It should be on why there is jurisdiction, because we can't open up the hearing itself on the merits without the board having jurisdiction.
Do you have jurisdiction over whether the appeal was properly granted? Of whether the permit was properly granted or approved?
Which permit?
No.
Yeah,
There's nothing in the administrative appeal is, well,
So just for clarification, which permit? The permit to build the entire subdivision behind you, or
The
someone?
developments behind us.
Okay.
Yeah.
I don't know that we do. I mean, that was issued some time ago.
I can address that. Why the objection was not raised then and it's being raised now.
Ms. Mosher, could you speak into the mic, please? I
Yeah.
can't
Oh,
quite hear you.
sorry.
Yeah,
Yes,
there we go.
And also, Brendan, could you get your microphone closer?
Oh,
'Cause
sorry.
when you have to turn this way,
Yeah.
Okay,
yeah.
I apologize.
Yeah.
No, thank you.
Thank you, ma'am.
So, again, we want to be very careful at the beginning of this. We want to grant you the hearing if it's within our purview to do so. We absolutely want to give you that opportunity. But if it's not, we don't want to get into the specifics of anything because it's really not something that we should. So we're going to kind of walk a tightrope here for a second. And
it's, at the end of the day, it's this board's duty to determine it has jurisdiction as well. So I think giving the applicant the opportunity to be heard on that issue to help make that decision, I'm going to ask this board to make that decision first before we get into the presentation on the actual merits.
so since I'm not a legal scholar by any means, I didn't even sleep at a Holiday Inn last night, let's do it this way. I'm going to ask you to start with what you think is pertinent to the questions that we've brought forward. At some point, if the attorney to my left, Brandon, decides that that's wandering into a territory that's dangerous for us for some reason, I'm going to ask him to speak up. Does that sound fair to you?
Yes,
Okay.
and can I ask, is it Mr. Mazer?
Correct.
Who you represent?
I represent the board.
Oh,
He's
but
just
you're
helping.
not, you're not a board member?
No.
Okay.
I'm the attorney for the board because the typical town attorney had opined on aspects of this application in the past. They are representing the code enforcement officer here.
Okay.
And I'm representing the board.
Okay. Shall I plunge ahead or?
Let's forge ahead for a second and see how we do. How's that?
Okay, just one other concern I have is the fact that your company stands to make about $8,000 digging a drain from the spillway at the back of my backyard out to the catch basin. If this appeal is not successful. It sounds like a financial conflict of interest to me.
I understand, and I'm happy to step aside. If you ask me to do that, I'll gladly do that. I have no. If you're more comfortable with that, I'll hand the mic to.
Nothing
the court.
against you.
No,
but
that's fine.
But I do see it as a conflict of financial interest.
Sure, and just for the record, I'm happy to step aside. The way I see that is I get paid the same whether we do the job for you or not. So I won't personally. I don't own the company. I get paid the same amount of money whether we do the job for you or not. But if it makes you more comfortable, I'm happy to step aside. Is the rest of the board okay with that? I mean, does that?
Yes.
I would recommend, given that the
I think
applicant has
you
raised
should,
the
yeah.
issue, that you recuse yourself from this item.
Happy to do so.
Okay.
Thank you.
Thank
So,
you.
Just before you begin, ma'am, who's acting as chair?
That would be me.
Okay, thank you.
My name is Carol Mulker. I'm a retired administrative law judge residing at 10 Lawn Avenue. And the reason we're here now instead of 7 years ago, when a conditional permit for the neighboring project was approved, is because information was withheld. The town prevented any timely objection by concealing facts from Lawn Avenue residents who asked but were never told how the development's drainage would work. Residents were never told that the town would violate its own land use code by approving development on land with periodic standing water. And we object to that violation. Never told that all development stormwater would be concentrated and directed to our backyards, not to the town's town storm drains. And we object to that concentration and direction without legal easements. Never told that the town would violate state regulations by permitting 7 acres to drain to an under-drained soil filter with a maximum capacity of 2.5 acres, and we object to that. Never told that the town would direct and approve digging a hidden spillway across property lines to carry unfiltered pollution into Lawn Avenue backyards. We object to that ongoing trespass and nuisance. Never told that the town would oversee and approve Snowbird piping a periodic waterfall of unfiltered pollution directly into Lawn Avenue backyards. And we object to that trespass and nuisance. Never told that the town's 2017 conditions of approval and the state's DEP permit would be consistently violated with the town's blessing, including no stormwater inspections or maintenance, no replanting of destroyed tree buffer behind our backyards, and no rebuilding of the level spreader built in 2017 to keep Snowbird's unfiltered pollution out of our backyards, and we object to those violations. Residents were never told that Gorham Stormwater Enforcement Authority and Stormwater Compliance Officer would utterly ignore enforcement and compliance with permit conditions from 2017 on, and we object to the town concealing all of the above and refusing to communicate with residents about all of the above violations of state law, local law, and the 2017 conditional permit. Due process requires giving residents notice and an opportunity to be heard before their property rights are violated. But these residents never got notice of what the town was overseeing and directing and approving when it collaborated with the neighboring development in a common scheme to flood and contaminate our property with unfiltered toxic pollution. In my 72 years, I've never before had an issue with any part of any city government, never wrote a letter to the editor, or spent far more time and money that I can afford taking on this kind of problem. And what I have spent is far less than what some of my neighbors have had to spend. And I have to say, we shouldn't have had to do any of this, because if the town officials had done their jobs from the beginning, none of this would have happened. Their stonewalling is the reason we're here now instead of 7 years ago. The conditional permit should be revoked for violation of permit conditions, state law, and town ordinance, or they should be suspended pending
I really need you to address the jurisdictional issue and how, where under the ordinance they have jurisdiction to hear anything. Is there to accept, they're allowed to hear where there's an alleged error in any order requirement decision, except for in a site plan review of the code and for decision. So I understand the issue. I need them to be able to make a determination that they do have jurisdiction.
So does the board have jurisdiction to hear whether a conditional permit should be revoked for violation of the conditions? My understanding is that it does.
They're based, and I'll defer to the board and to allow me to opine.
Please opine. Randy.
There is no violation in the record that is appealable at this point. If there was a violation issued by the code enforcement officer, then this board would have, but at this point, there has been nothing issued by the code enforcement officer. So it's a little bit of a
Can I be heard of?
backwards.
Our scope is very, very limited to 3 things: administrative appeals, and then there's 2 variances. Under that administrative appeal, we need to actually have a decision or determination by the code enforcement officer that can then be appealed. If there's no decision, then there is no there is nothing to appeal.
No appeal.
When complaints and/or objections are raised for 7 months to the code office and the code office refuses to respond, my understanding is that the code office's inaction can also be appealed to the board.
So, ma'am, two notes on this. Insofar as you're looking at appealing an approval, there's a 30-day timeline that appeals need to be filed after a decision. So if we're looking at an approval that was approved 7 years ago, we're well past that timeline. And our ordinance, if you look at 1-4B, 1A, or B of the Land Use and Development Code, says that you can't appeal a negative, right? So the failure to issue a decision or to take an enforcement action or to do something else is just not appealable to this board under Taunton ordinance. That doesn't mean that you might not have other means of recourse somewhere else, but this isn't the right forum for this.
So you're saying that in order for you to have jurisdiction, the appeal would have had to have been filed within 30 days of permit approval in 2017?
If you were, and I don't even know that would do it, but there's, at the very least, I know that there's a 30-day timeline, right?
Okay.
So,
Not necessarily, because the ordinance, it does not allow this board to hear appeals on subdivision or site. Depending on what you're appealing, your recourse would have been through an ADB to Superior Court if it was on the subdivision or site plan applications, or special review if that was the case. I don't know what the original in 2017 was.
Well, these were condominiums, which are not subdivisions.
They are, or likely were. So your recourse would have been, you may have some private property disputes, but this board needs to have jurisdiction in order to hear an appeal. So I'll leave it at that for this board to continue to discuss.
I'm still not clear about when we could have raised an objection to the permits.
When, depending on what the applications were, within public comment as the public hearing occurred, and within, I believe, 30 or 45 days after the approval by the planning board, if that's the case.
And what if information was withheld so that we didn't know what to appeal or object to?
I'm going to caution the board from opening this up to public comment yet.
Yeah,
you're not an applicant.
Yeah, let's please not open it up for public comment yet until we have.
One quick thing.
I would caution the board from opening it up to public comment beyond the applicant at this point.
we'll take the advice of our attorney.
Okay. She was here 7 years ago. She was raising these issues 7 years ago, and she and her husband participated in these hearings, or I guess it was the planning board hearing that she participated in, and he walked around on walkarounds with the developer and town representatives.
Understood. And again, that would have been, she would have had standing to appeal the decision of the planning board. That would have gone to Superior Court. So I just need you to, if you can point to something in the ordinance that gives this board the ability to hear a non-action by the CEO, which is what we're here. That's what this board needs to hear something and take action on. Do they have jurisdiction? Because I need to, in the findings of fact, conclusions of law, one of the check the boxes is the board has jurisdiction pursuant to the ordinance. And you are more than welcome to, it is your discretion to open this up to, on the narrow issue of jurisdiction, to the public if you want. It's not necessary. And I think it's also perfectly appropriate if you do that to hear from the CEO to confirm that no violation. Whatever you need to do to make sure you have jurisdiction, I will leave it to you, but I would just keep the discussion very narrow. And then if you do decide you do have jurisdiction, we can expand beyond that.
So we're going to open it up for discussion on the sole issue of do we have jurisdiction to hear this appeal? Comments?
Go ahead.
I was going to just chime in and say, I don't, from what I've heard so far and what I've read in the package, I don't think we do. My personal belief, unless I can be convinced otherwise, is that this is and I hate to say it, but it sounds like an abutter issue, almost like a boundary issue.
Scott's
So-
not involved in this, right? Scott?
So Scott would be involved to the extent of confirming that there hasn't been something issued that would be appealable.
Yes.
So, but
Can we ask the code enforcement officer, Scott, was there a decision that you issued, a denial, that we can discuss here?
I have not issued, sorry, thank you. I have not issued a violation letter at this time.
Thank you.
Scott was not the code enforcement officer in 2017. It was Chris Poland.
Understood, but we don't on the record have a
Active.
active denial. We don't have, in order to have standing, we need, so again, in powers and duties of this board, under administrative appeals, which is what this is filed under, in subsection B, well, the administrative here, so let me read this just so everybody understands. To hear and decide, it is alleged that there, where it is alleged that there is an error in any order, requirement, decision, or determination made by the code enforcement officer in the enforcement of this code, except notices of violations, those sections, that's not what we're talking about. Section B, decisions or determinations by the code enforcement officer not to undertake an enforcement action shall not be appealable to the Board of Appeals.
Chris Poland's name is on the approved permit for these developments. So he was approving, on behalf of the Code Enforcement Office, these developments on the approved permits. That's what we're objecting to. Doesn't matter who the current Code Enforcement Officer is. The Code Enforcement Officer keeps accurate records of whatever they've done. So in the year I've been here, there have been 4 different code enforcement officers, but that shouldn't matter. It's what the Code Enforcement Office does. And that permit was approved by the Code Enforcement Officer at the time. That's what we're objecting to.
So I think that there may be a private right of action here. I think you may have a trespass action. I think you may have all kinds of things that you may be able to bring in Superior Court. I don't see anything from anything you've told me, from anything Scott said, that puts this within our purview. We're limited. I mean, there is a very clear, you said you were an administrative law judge, right? We are limited by administrative law about the things that we can hear, and there's just nothing that we're hearing from you that falls within those narrow exceptions. So
Okay.
for that reason, I'm going to vote that we do not have jurisdiction.
Okay. We're just making a record for Superior Court, so that's fine.
So I would ask if the board's done deliberating to actually take a vote on the jurisdictional issue, and based on that jurisdictional issue, take a vote on whether to formally approve or deny the application. If you don't have jurisdiction, it would be presumably a denial of the application.
So are we going to, can you say that again? I'm sorry, Brandon.
So, based on the facts and the conclusions of law, the appeals board finds that it does, let's do it in 2 votes.
I can make a motion.
Yeah, go ahead.
So I will move to deny this appeal due to a lack of jurisdiction to hear the issues that were raised.
Okay.
I would second that.
Oh, second? You got a second?
Dan. Don. Dan.
Yep, okay. And
So
then,
my
so
only
it's,
question is, did we hear all of the issues?
you don't get to if you don't have jurisdiction, you don't get to the other issues.
Right, but I mean, was there anything
violation.
that we could, did we hear everything that was relevant, is what I'm asking.
I guess that would be a question for the applicant, right?
I'm not clear on when we had a notice and opportunity to be heard on something that was going to violate our property rights. When did that happen?
It would have.
So we're not here tonight to answer that question because we don't have the history of this approval in front of us, candidly. Like, there is a standard process for how these are approved. I assume that process was followed, but regardless, that doesn't place this within the jurisdiction of this board.
If I provided you with the history of how it was approved? No, you don't want to hear that. Okay.
It's not that we don't want to hear it, it's just that we don't have jurisdiction to hear it. They're separate issues.
So the motion was made to deny the appeal, so approving this would be denying the application. So the affirmative vote would deny it.
Since we had comment in between, should we
Yeah, it probably makes sense to restate that motion too.
That's fine. I had it that you moved to deny the appeal due to lack of jurisdiction.
Okay.
And it was seconded by Dan.
Dan seconded? Okay. All those in favor of, this is a negative, right? The motion was to deny.
To deny, so.
All those in favor of denying jurisdiction, only jurisdiction.
Okay. Opposed. Similar to the last, I will get this forward. Unfortunately, now you're going to have to come in on Thursday to sign as acting chair. But I'll get this. What I tend to do with other boards is I'll send 2 separate emails to the individual chairs. I'll BCC the board. As as Mark mentioned, don't correspond about, it's really about, did I miss anything? Did I get it right? Nothing substantive should be discussed, and do not reply all. I'll BCC everyone though, so. Okay. So I think at this point, unless there's new business.
Nope, might as well finish it out. Nice job, by the way.
Are there any last comments from the board? If not, we can adjourn.
I move that we adjourn.
I second that.
All in favor?
All in favor?
We all get to go home?